Yeah, no, thank you very much for the opportunity. Yeah, my name is Jonathan Campbell. I'm the director of the Noordwes-Universiteit Law Clinic in Mukunda in the Eastern Cape. I am an attorney. I was previously in private practice. I'm now, if you like, a part-time practitioner and part-time academic. The law clinic runs as an ordinary law firm. And we also provide practical legal education to every LLB student who comes through the faculty, and provide a free legal service to the indigent community of Mukunda and the surrounding area. And we have an outreach program throughout the Eastern Cape through about 40 paralegal advice officers. So that's where I'm coming at this topic from. One of the courses, I teach several courses. One of the courses that I teach is ADR, with a focus on negotiation and mediation. So this is something that's very close to my heart. And I am a trained and accredited divorce mediator as well. What I'm wanting to do in this paper is to propose that much of what ADR practitioners do can usefully be conceptualized as preventative lawyering and therapeutic jurisprudence. Now, these are terms that you may or may not have heard of before. And I have found it insightful to view the practice of ADR from this perspective. I found it enriching to take a step back from the hurly-burly of ADR practice and teaching and to consider conceptually what we're aiming to achieve. And this is more than just a theoretical approach. This is very much a practically grounded consideration. So in this presentation, I'm going to be unpacking these two very interesting concepts and showing how they relate both to our practice and our teaching of ADR methods, both as ADR practitioners and ADR teachers. And I will conclude by trying to show how important they can be for professional identity formation for young practitioners. This is a term some that may be familiar to you or maybe not. Professional identity formation, and I'm just really glad that there are students present to hear this as well. So to start with, I posed a number of questions that are implicit in these concepts of preventative lawyering and therapeutic jurisprudence. And please take a minute to read them and think about them. There's little point in me reading them out. I'll just pause for a moment. So these are value-laden questions that would make many lawyers uncomfortable. Most lawyers subscribe to an approach which is the law is the law. Okay, it's black letter law. And yes, there is a place for values and constitutional values, but don't take us further than that. I know that I'm probably talking to a group of largely sort of ADR converts, if you like. But should lawyers be concerned with psychological and emotional issues? Should we identify ourselves as lawyers? Should we identify ourselves as carers who give attention to the general well-being of those who come into contact with the law? No, we are not members of the caring profession. I think that is clear. But does that mean we should not care? Okay. Some thoughts. So just to take you first through, before discussing the link of these concepts with ADR, I just wanted to give you an overview of the traditional understanding of what preventative lawyering is. It's regarded as the giving of legal advice aimed at preventing clients from making bad decisions, as opposed to patching up problems after they've already arisen. Kind of band-aid approach to lawyering. And it sounds a bit rude to say this, but That is what most of lawyering is about, is patching up problems after they've happened, after things have gone wrong. What preventative lawyering is trying to do is to anticipate those things and put in place steps and measures to prevent things from going wrong. We'll look at examples in a moment. So it envisages the lawyer as counselor, planner, and facilitator. It aims to enhance opportunities and minimize risks. It aims to identify legal soft spots where one could be vulnerable and opportunity spots to be exploited, or trouble spots to be avoided. Okay. It involves preemptive counseling that seeks to help clients to conduct their affairs in ways that are advantageous to them. For example, the preparation of a will to enable estate planning, or to avoid consequences that are contrary to their interests. For example, advice against concluding a credit agreement that the client cannot afford. So to this extent, it's much like preventative healthcare. So HIV/AIDS counseling and health practice, for example. And some authors propose that it even envisages regular legal checkups, analogous to medical checkups, especially for those of us who get a bit older. For example, in relation to estate planning, because personal circumstances and tax laws change, as they will from time to time over the years. One of your heirs dies, for example, so you need to draft a new will. So the best way of unpacking this further is through an example. So credit law is one of my interests, research interests, and so very germane to this, and also very germane to this discussion. So a client, and we work with mostly indigent clients at the law clinic, and so this is a typical scenario. The client borrows 5,000 Rand because she wants a TV set, okay, which is a luxury item. The current regulations permit that credit costs can be charged up to these maximums. So the client will have to repay nearly 7,500 Rand over 6 months. That's nearly 50% more than the initial price. 1,237 per month. So credit costs of about nearly 2,500 Rand are paid altogether. And there's the calculation of how I get there. So few consumers understand this high cost. And it's really important that if you have the chance to counsel a consumer before concluding a credit agreement, that you help them to understand this. Even my final year law students, some of them, their numeracy skills are really poor. So it's not just those who are indigent or lacking education. So assume that this client's monthly income exceeds his expenses by 500 before concluding the credit agreement. Preventative lawyer's advice, based on a quotation, it's called pre-agreement disclosure in terms of the National Credit Act, states that the client will become over-indebted if she borrows this money. Okay. She can't afford 1,237 per month. She only has 500 Rand left over. Rather, she should be advised to save 500 Rand per month, live without a TV set for 10 months, and then buy it for cash. No credit costs at all. Because not to do so would put her at enormous risk, over-indebtedness, judgment, which could have an adverse impact on her credit rating, emotional stress, and much more. So the purpose of preventative lawyering in this example is to prevent this client from making a potentially disastrous decision, so-called trouble spot, and to propose a more constructive course of action, a so-called opportunity spot. Okay, so both sides of the same coin. So what has all of this got to do with alternative dispute resolution? Well, a further element of preventative lawyering involves facilitating the resolution of disputes without resort to the courts through promoting ADR methods. So in many instances, negotiation, mediation, and other ADR mechanisms can be used expressly to prevent individuals from being subjected to expensive and protracted litigation, which is often acrimonious and alienating. We've heard a lot about this already today, so I don't want to repeat. In divorce mediation, for example, it can have a role of preventing the further deterioration of the relationship between the spouses, which is important not just for their relationship, but for the children as well, because the parties will still have to deal with each other as parents. So what you're doing indirectly is giving explicit consideration to the emotional and psychological well-being of children. So this is what divorce mediators do. I'm just trying to show the preventative lawyering aspect to this. And preventative lawyering is equally important in the context of litigation, where settlement can be negotiated to achieve not just positive financial outcomes, but also for the sake of non-legal issues. For example, amicable relations between warring parents. And it's not easy sometimes to reconcile legal on the one hand as opposed to non-legal imperatives on the other, which can be at odds with each other. So if preventative lawyering is important for all these reasons in the practice of ADR, how does it impact on legal education? I would argue that there's been a deification of the adversarial system. Think about it. We talk as lecturers, as law teachers, repeatedly about the case, which always implies a court case. And we love our long lists of decided cases that we give students to read. Of course, they're important. But it gives over a sort of hidden message that that is what law is about. Courts and doing battle in court. We also provide hypothetical cases in problem solving. And our students deal with real life cases in the law clinics. There's much that has been written about the hidden curriculum, which I don't have time to deal with here, but this is one very good example. In practice, rather, the vast majority of cases are resolved through preventative lawyering methods, especially negotiation, achieved through the agency of skilled lawyers. And these skills can be taught and they can be learned. And settlement terms usually depend as much on a multitude of non-legal as on legal issues. So, for example, issues of costs, medico-legal reports, or whatever, which have been mentioned today already. So, a further extension of preventative legal education, which we've adopted in our law clinics, is education of clients and the broader community. Again, analogous to preventative health education, for example, in relation to COVID. Besides a better understanding of the law, for example, it's really important for our clients to understand that a sale of immovable property must be in writing and signed by both parties. The amount of money that changes hands between people purporting to sell or purchase a property is frightening. When there's nothing in writing, that sale is void ab initio. It might even transpire that the supposed seller was in fact never the owner of the house in the first place. Thought she was, but it's still registered in the name of the Gorgor, who died back in the 1970s. But besides this, how are clients to know that there are a range of possible ways of resolving disputes, not just the courts, unless they are educated or schooled in such things? Some are better schooled than others. And arguably an understanding of how the calculation of interest works in credit law, for example, is a life skill. How can you go through life? How can you purchase that lounge suite from Joshua Door or from OK Bazaar without an understanding and appreciation of how interest works and how scary it is, actually, So preventative legal education is the reason why many law clinics have programs such as these. Then preventative lawyering approaches can have positive and even therapeutic outcomes for the individuals or communities concerned. Yes, this is a lawyer speaking. And no, there are not many lawyers who are going to be very receptive to the idea of lawyers as therapeutic agents. So I'm being quite extreme here. But again, my guess is that most of you who are listening would probably subscribe to this view, otherwise you wouldn't be on this webinar. There is a field of study which has arisen primarily in North America called therapeutic jurisprudence. Adherents of this approach believe that law can be practiced in a humane and caring manner, with attention being given to both legal and psychological concerns that are present in the issue presented. So in a labor dispute, for example, the amicable negotiation of that dispute can be really important for ongoing relations between the employer and the employee, assuming the employee stays in employment with that company. And so this is really important for a favorable working environment. And the primary focus of therapeutic jurisprudence is on the roles and behaviors of the legal actors, clients, lawyers, judicial officers, as opposed to the law. It's putting people at the center of the legal controversy, if you like, as opposed to putting the law first. And it posits that lawyers can inevitably become psychological or therapeutic agents. Again, to illustrate these terms, let's have a look at consumer credit law. So we've already said in the context of consumer credit law that in relation to preventative lawyering, your trouble spots could be the extremely high cost of credit, the over-indebtedness that could ensue. The consumer ends up in a debt trap, has judgment taken against him, an adverse credit rating, gets blacklisted, so can't qualify for credit again. These are all trouble spots, right, that need to be recognized. But an opportunity spot, on the other hand, is saving money to acquire that TV set. No credit costs at all. Now I understand interest and credit costs better. I use the term credit cost because it's not just about interest. There's an initiation fee, there's a service fee, it all adds up. Okay. So there's an educational function there as well. So those are all legal, if you like, issues. Psychological soft spots, on the other hand. Other consequences of getting yourself over-indebted could be stress and anxiety, resultant poor self-esteem, impact on the relationship with others, especially those near and dear, possibly clinical depression, and so on. So these are psychological, emotional issues that we would ordinarily not concern ourselves with in the practice of law, but which I'm arguing one should concern ourselves with. Let's go back to divorce again. And quite an interesting insight that I've gained in the last couple of years is the fact that when we consider divorce process, we think primarily of the legal process. And yes, it has to be gone through. A court has to order that divorce ultimately. So whether it's in the high court or in the regional court, whether it's achieved through litigation or through ADR methods, at the end of the day, it's got to go through court, and it is a legal process. But the client is undertaking a parallel and often tougher process, the socio-emotional divorce. And there's a whole lot of issues there. The letting go, the sense of failure of the marriage, which results in low self-esteem, dealing with children's trauma, hectic stuff. We lawyers don't have the expertise to deal with this. We are not members of the caring profession. But that surely does not mean that we don't care about them or that we don't give them some attention, not as therapists, no, but through some understanding of these issues. A lawyer can build empathy, provide support to the client, and help the client on the road towards a more favorable outcome, both in terms of the legal outcome as well as other issues, other non-legal issues. So we can still be therapeutic agents, is what I'm suggesting. And this slide, I think, speaks for itself. We are not being therapists, but we can be therapeutic agents. We can be alive to softer, non-legal issues which need attention in order to, for example, minimize anti-therapeutic effects of divorce on children. And we all know about the contrary situation, the aggressive lawyer who can end up magnifying, exacerbating the acrimony between the parties and causing even more trauma to the children. That, ladies and gentlemen, is the antithesis of what I'm talking about. I'm suggesting that by being sensitive, by being attuned to the emotional and psychological needs of the parties, and even the way in which we conduct ourselves, we're not trying to fix those, but we're being aware of them, we're being sensitive to them. In some of the advice that we're giving, it might even impact on the advice that we give. For example, advising a client who's struggling to let go of the marriage. It's a big emotional step. But you can see that the writing is on the wall for both parties in that marriage, is to gently help that client along towards accepting that this is an inevitable outcome. Although one has to tread warily, because we are not counselors and we're certainly not marriage counselors, but we can still have a positive impact. And just a word about court adjudication. The way in which court matters are conducted, for example, by presiding officers, could have a huge impact on the human factor in the divorce, in any litigation. And in the children's courts, we know, those of us who practice there, that the way in which they are run, in an informal setting, in the magistrate's office or in a boardroom, magistrate adopting an inquisitorial participatory role in a more relaxed fashion, all of that lends itself to a more friendly and child-friendly approach to conducting litigation. So there's much that we can learn from children's courts and from customary courts. And an example is given there with a quotation from Rotenbach, which I think speaks for itself and speaks to the key tenets of Ubuntu. Which brings me to, I mentioned earlier that the term therapeutic jurisprudence has its origins in North America, and I found it very useful to consider. But it links very, very closely. These are not new ideas, North American ideas. In South Africa, we've come a long way in looking at concepts such as Ubuntu. It's been around forever. The values of group solidarity, compassion, human dignity, respect, etc., which links so closely, of course, with the foundational principles of our Constitution, our very Constitution, and the developing notion of an ethic of care in our legal ethics law. So these concepts of preventative law and therapeutic jurisprudence, I'm very keen to kind of tell people about in forums such as this, because I really believe that they can further enrich South African scholarship and practice in this broad field, which is wanting to place people in context, people in their context at the center of the legal controversy. Finally, there are many lawyers who subscribe to a preventative and therapeutic approach to lawyering. You might feel, well, this is what I do. I've never heard of these terms before, but this is what I do, and quite right. That's what I discovered when I started reading about these terms. Lawyers who question the traditional expectation that all cases must be litigated and fought by hard-nosed lawyers with a winner-takes-all outcome. Lawyers who strive for humane ways of resolving disputes and who care for the well-being of their clients, and not only for success in winning cases. I believe that by conceptualizing these ideas and thinking them through, these alternative fringe lawyering practices can become more mainstream, widely recognized and legitimized. And in this way, young lawyers and law students who subscribe to these practices can be encouraged and supported in their own professional identity formation. And indeed, we can begin to identify ourselves as preventative lawyers. I have started to do that myself. I could have said so in my introduction. Because I think it is helpful because of what preventative lawyering stands for and aims to achieve. It captures quite well what many of us try to do as ADR practitioners. Thank you very much.
Thank you very much, Jonathan. I'm actually taken a little back, with your presentation, and it makes so much sense to me personally, and this being one of the motivations of having this colloquium, so that we could expand on what we can do better, to not educate, but to bring ADR into the fore, and make people understand that we need to make some kind of shift, as lawyers. Something that came to mind when you were doing your presentation was the access to courts, Section 34 in our Constitution. We talk about this, but what does it actually mean? And how can we as academics, I speak in my personal, from a personal perspective, how can we as academics actually make a difference in this regard? The floor's open. Any questions, any comments to Jonathan's presentation, colleagues? Mr. Tava, welcome back. Yes, you can go ahead.
Thank you. Just some commentary on the presentation. Great job, by the way, sir. Very professional and insightful. And I couldn't help but keep hearing Mr. Fenter's presentation playing in the background while you were presenting, because the duality of what you're preaching and what he's speaking of, the lack of in his presentation, really just shows how far we now have to go in actually analyzing the human aspect of legislation and of practice, whether it be mediation or even litigation itself, and looking at those soft spots, because like Mr. Fenter did say, those soft spots then end up becoming the stumbling blocks that then subconsciously end up ruining everything. So it really is insightful and very inspiring to hear that the legal field is taking this refreshing perspective and actually starting to look at the human side of the legal field. Because when I wanted to come into the field of law, I was never looking at the grimace of the legal department being this emotionless brute that just looks at making money. I always looked at the human side of justice and how we can actually help people genuinely. So I'd just like to commend you on your presentation. I think it's very important and a very important conversation that we need to continue having about the soft spots that actually mean so much more in hindsight.
Yeah, thanks for that. My own sense is that, and this comes from sort of decades of working in this field, is that it is unrealistic to expect most lawyers to subscribe to these kinds of views. And in fairness to the legal profession, there is a whole lot of knowledge of substantive law, procedural law, and skills that a lawyer has to bring to the table in the practice of law. And now, by people like myself suggesting that we have to become more attuned to people-related issues and psychological issues and so on, causes many law students and young lawyers to say, well, hang on, no, this is a step too far now. And so I have sympathy with those who have that approach. And yet the fact remains, as you say, we are dealing with human beings, we are dealing with people. It's people first. And when I started out in practice, in private practice, I was shocked. I was absolutely shocked that it was money first. There's just no question about it. And it's partly born of the fact that what we are selling as lawyers is our services and our time, and that costs money. And people want to make a living, and they want to make a good living, because that's what lawyers do, are supposed to do anyway, is make a very good living, become very wealthy. It doesn't happen for everyone. So that's the expectation. And you're a professional, and you can, and so on. So I was shocked when I went into private practice. It was money first, people second. Absolutely no doubt about it. I was with a very respectable firm in Cape Town. There was no difficulty with its own ethics, the way it practiced, but that was the reality. And I thought, I've come to the wrong profession. I've studied for 5 years, and I've done my articles, and here I come as a young attorney. And so that's how I ended up at the University Law Clinic, because we provide a free legal service. We don't have to worry with the fees, don't have to turn so many people away because they can't afford it. And so I'm comfortable there. And what I would say to you, Africa, is, if you, like many others, can identify with these kinds of approaches to lawyering, that can help to define you and to identify, it can give you an identity, a sense of identity of where you might belong. You don't know for sure yet. You're not there yet. You're not in practice yet. I presume you're a student, sorry. But just be open to that possibility, and that you could end up being part of a community of, if you like, fringe lawyers who view the practice of law somewhat differently, putting the person at the center as opposed to the law, and all that entails. And it's a value judgment. It's a value-laden approach. You're making a value decision. This is what I'm going to do, and this is how I'm going to practice law. And that would be a very brave one, I believe. And we need to support each other, those of us who are in this field together. Support each other and support our students, which is why I say there's such a role in our legal education as well, for working closely with students in their own professional identity formation. Thank you.
Thanks, Jonathan. Thank you for your question and your comments, Mr. Tava. Colleagues, any other questions or comments for the presenter? Thank you very much for your presentation, Jonathan. It's much appreciated.
Thank you. Thanks for listening.
Okay. Hi, our next presenter is Charlene.